And then our last order of business for the day is just going to be a quick overview of House File 4075. I believe Mr. Dibble is going to explain that to us.
Thank you, Mr. Chair. Yes. House File 4075 is a collaborative bill between myself and Chair Moeller, and it has to do with a 2015 bill that became law that said that if you go through the court process and you are found guilty of domestic violence and the courts order you to turn over your firearms, that you need to turn over your firearms. And we found out that in less than 2% of the cases where those firearms, was that being followed up, those orders were being followed up on. So we have worked with some stakeholders over the last several weeks here, and I asked Mr. Dibble from House Research just to run through what we've come up with here.
Very well. And just so members know, we're not going to be taking this bill up for a vote today. We're just getting this information from nonpartisan. Go ahead, state your name and
Thank you,
describe the bill.
Mr. Chair and members. Jeff Diebel from House Research. We're working off the DE2 amendment to House File 4075. I'll try to move through it as quickly and concisely as possible. Many of the changes are duplicative because what the overall structure of the bill is to consolidate provisions in domestic violence cases where an offender or a respondent in a petition case is ordered by the court to surrender their firearms. And those provisions are sprinkled throughout our statutes right now. They largely track each other, but there are differences. And so this effort is to put all of those provisions in one section in Chapter 518B. So beginning in Section 1, Sections 1 and 2 deal with CHIPS cases where there's a request for a petition in CHIPS. And on page 2, you'll see that it directs the applicant to identify if they know where a respondent's firearms are so that the court is aware of their whereabouts, and if they are surrendered, then they can be helped them identified. Moving on to pages 3 and 4 and 5, this is also part of CHIPS, but this is where we're taking the language out of existing statute and we're recodifying it subsequent section in the bill. It also, the new language on page 4 talks about if you are ordered to surrender your firearms in one of these cases, you also are ordered to surrender your permits to carry and your permits to purchase. Moving forward to the page 6, this is, again, about the OFP petition, same with the CHIPS, where you're directed to tell the court if you know about the respondent's firearms. And then jumping forward to pages 9, 10, and 11, this is almost identical language to what we saw in the CHIPS case. It mirrors that for the order for protection statute, again, telling the respondent that if you have permits to carry and you're ordered to surrender your firearms, you must surrender those as well. And then directing the practitioners to the new section in 518B. Moving forward to the section 5, on page 14 at the bottom, you'll see where current statute on occasion refers just to a pistol or to a particular firearm that was used in a case. And in this case, the court would be ordering the person to not have possession of any firearm. So this would just clarify that language to say that not only are you ineligible to have that pistol or the designated firearm, you're ineligible to have any firearm at that point. Moving on to section 6 on page 15, this is the substance, probably the meat of the bill. This is when we talk about transfer of firearms in certain domestic violence cases. And I just want to highlight a few of the provisions in here. It does provide for transfer to an FFL, a federal firearms license holder, law enforcement, or a third party that it doesn't live with the respondent or the defendant. Again, much of this language is already in statute. I'll try to highlight where it deviates from that. On page 16, there is a paragraph C that the third party transfer is, as drafted here, would need to take place at a law enforcement agency and either supervised by a peace officer or conducted in a space where there's a video camera. I think this is commonly used for Craigslist transfers so that people can have some semblance of security when transferring things. So the expectation would be that these transfers would be held there and then video recorded by the law enforcement's cameras. Moving down, you've got paragraph D talks about the law enforcement and dealer requirements and responsibilities. Paragraph E talks about the return of firearms for those that are temporarily transferred to dealers and law enforcement. And then paragraph F grants immunity to law enforcement for the storage and handling of the firearms. Moving on to page 17, this is the proof of transfer process. This is largely the same as it is in current law, where the respondent is expected to complete a proof of transfer and return that to the court, acknowledging that they've transferred any firearms they have. Paragraph C under subdivision 3 is the third-party affidavit. So if I transfer a firearm to a third party, they need to acknowledge receipt of the firearm and that they are under a legal obligation not to allow the person to have access to those firearms. There's also a provision for allowing, for those who don't own firearms, to declare that they do not possess any firearms and submitting that to the court. Moving on to page 18, there's the duty to file all documents rests with the respondent or the defendant, and then it also reiterates that law enforcement, county attorney, city attorney, as well as household members can still seek an ERPO even if this provision is activated. Section 4 is a new provision that addresses compliance hearings. This would be required to be held by a court after they order a person to surrender their firearms within 10 business days of issuing that order. They would ask the respondent or defendant to come back to the court and explain that they've complied with the transfer order. This has built-in protections to protect the respondent or defendant's rights against self-incrimination. And the goal is there to get them, encourage them to comply without having to subject them to legal jeopardy for complying with the order. And then I think we can, you can quickly move through. The remaining provisions are duplicative of what was in the earlier part of the bill. It's just conforming changes in the domestic assault, harassment statute, and then pretrial release for violent offenders. But they all comply with, or they're consistent with what we discussed in the CHIPS and OFP provisions.
Thank you for that description, and for those members remaining, thank you for your indulgence. The meeting is adjourned.